Good morning, everyone. Okay, I'm just going to wait for some people to tune in. Good morning, everyone. Happy last day of August. We're getting into the last quarter of the year. I feel like this year flew by fast. It's so unreal. Hi, guys. Hi, everybody on Instagram. Hi, everyone on Facebook. Hi, everyone on YouTube. If this is your first time tuning in, definitely comment in the box and let me know it's your first time. My usuals, definitely say hi. Let us know where you're tuning in from. Good morning, Shauna on Instagram. For those of you who are just following me for the first time, I would love for you to subscribe to my channel on YouTube. I'd like you to follow me on Instagram and Facebook and like my page. You can also hit the notification button so that whenever I go live, you will get an announcement that I've gone live, and you can tune in. And then I also love for you guys to share this video. Okay, share this video just in case you have friends or family that might be interested in the immigration matter, so that they can watch it as well. So let me introduce myself. My name is Aisha Chidole. I'm an immigration attorney. I present clients all over the United States with their family immigration matter. Your location doesn't matter. Immigration is a federal law. So, we can represent clients regardless of what state you're in. My phone number here is 407-995-6567. And, as always, definitely love to hear your questions. You can type your questions in the comments, and, I'll try to get to as many of them as I can, before I have to jump off and after I've talked about my topic. So I have a good one for you guys today. So today I want to talk about overstaying your visa and being married to a green card holder and how that affects you from adjusting your status. Now, what do I mean when I say overstay? Let's start with that. So, a lot of times people get confused when you ask them, is your visa valid, or, when did you come in here? And they'll tell you, oh, I have a 10-year visa. And I always say to them, it doesn't matter whether you have a 10-year visa or not, but what does your I-94 say? So if you don't know what your I-94 is, your I-94 is a document where your entry is listed when you entered and how long you're supposed to stay in the United States. Sometimes they will stamp it on your passport, but you can also retrieve it from online. And it will tell you what category you came into the United States. Like, did you come on a B1, B2? Did you come on a student visa? And how long you can stay here. So you could have a 10-year green card, but generally the average time that you will get is 6 months or less to enter into the United States. So when you come into the United States, you need to stay 6 months or less. This is different if you're from a country where there's a visa waiver. So for example, in the UK, where if you're a United States citizen, I'm not a United States citizen, if you're a British citizen, you have what we call a visa waiver. So while you don't need a visa to come into the country, because you can come in on ESTA, you have 90 days before you leave. So in that case, it's 90 days, but generally it's usually a 6-month stamp that they give you. Okay. And so when I say overstay, I am talking about overstaying that 6 months, not the whole term of your visa, overstaying your entry. So when you enter into the United States and you've basically overstayed a time on your I-94, that's what I'm referring to. So typically, if you come into the United States with certain types of visas, including a B1, B2, which is the same thing as, a visiting visa, or also known as a tourist visa, normally, if you're married to a U.S. citizen, they will forgive that overstay, and then you can do what we call an adjustment of status, meaning that you can apply for your green card while you are within the United States without having to leave the United States to get your green card or finish your process. However, the rules are different if the person that you're married to is a green card holder. So they don't consider, so even though your husband or your wife is your immediate relative, for the purposes of immigration, they don't consider them immediate relatives when they're green card holders. So you don't have automatic visas or automatic green cards. You have to wait till a green card is available. And I do see your questions. Definitely keep them coming. I will try and answer all of them as much as I can before I have to jump up from here. So, if you're sorry, what was I saying now? I just forgot what I was saying. Okay, so yeah, if you're married to a green card holder, you cannot overstay your time and expect to adjust your status. So let me give you all the different scenarios. So if you're married to a green card holder and you've overstayed your visa, they are not going to forgive that. I'm going to get to the exceptions because, as I'm sure you guys know, there's always an exception. So normally they're not going to forgive that, right? You have to file for the I-130. Once the I-130 is approved, you have to request for a hardship waiver. If the hardship waiver is approved based on your qualifying relative, then you have to go back to your home country, and finish up what we call consular processing. So that is the way it works if the person that you're married to is a green card holder. Again, there are exceptions to the rule. So now here are some of the exceptions. If you're married to a green card holder and the person is abusive to you, they're extremely cruel to you, and you're able to qualify as a VAWA applicant, you can finish your process in the United States. So I will speak about right now. So for instance, the month of September, visas are currently current. And what that means is that visas are currently available to spouses and children unmarried under 21 of green card holders. So I'm going to get into what that means for you. So it means that if you're married to, my Instagram page keeps blacking out, so I don't know if it's pausing me. So if you see me moving my hands, that's why. So if you're married to a green card holder and that person is abusive towards you, you can actually adjust your status simultaneously at the same time when you submit your VAWA application. And what that means for you is that while your process is pending, you will be able to get a work permit and you'll be able to get a travel permit. And, fingers crossed, God willing, you'll be able to get your green card. Okay. The second option is if you're in the United States and you're married to a green card holder, and it just so happens that you have not overstayed your time. I'm sure some of you are like, well, what scenarios are those where you've not overstayed your time? So examples of those scenarios are, for example, if you're here on an F1 student visa and you're still a student, you're still in school. So, F1 usually is duration of stay. So as long as you're a student, you're still in status, right? So in that case, right now, normally there might not be a visa available, or you have to wait your time. But right now, because this visa has been current for the last 2 years, I'll say year and a half, it's been current, which does not happen because 2 years ago it was like a 2-year wait time. So because it's current and your visa has not been, and you've not overstayed your time, you can adjust your status, in that situation as well. So let me see. I feel like there's one more category that I want to talk about when it comes to green card holders. Okay, yeah. So good morning, Nadine on Facebook. Good morning, Femi. Good morning, Stanley. Good morning, Sophia from Tennessee. Good morning, everyone. Yeah. You guys comment in the box. Let me know where you're all tuning in from. So the last category is if you're married to a green card holder and you've overstayed, the other option for you is to determine when is your spouse eligible to become a United States citizen. Because what you can do is if your spouse is eligible to become a U.S. citizen, they can still apply for your I-130, right? And while your I-130 is basically your petition for alien relative. Basically, it's what it's saying is that it's true. You guys are husband and wife, or wife and wife, or husband and husband, but it doesn't do anything for you. It's just establishing that. So whenever people come to me and say, oh, I have an approved I-130, I'm like, that doesn't do anything for you. Doesn't give you a work permit, doesn't give you a green card. It's just saying, okay, I believe you guys have a relationship. So that person can still file your I-130 and then apply for their naturalization if their naturalization is due. So that as one is processing, the other one is processing, so that by the time your I-130 is approved, their naturalization will be approved, and then you can convert your application to you being married to a U.S. citizen. So that is another option for you if you're married to a green card holder, and you've overstayed your time. So I think I covered everything that I wanted to as far as green card holders. So again, just a quick rundown. If you're married to a green card holder and you've overstayed your time, one of your exceptions, you can generally not adjust your status. You usually have to get a hardship waiver. An exception is one, if you're a qualified VAWA applicant, then you can stay here and adjust your status. The second exception is if that person is eligible for citizenship and they can apply for citizenship while they're applying for you, so that you can then do a conversion of the application once they naturalize. Otherwise, if you're here and your status is still valid, meaning you still have your visa and your entry time has not expired, and they're green card holders, in that instance, you can also adjust your status. Okay, so I'm going to take some questions. Let me start with Instagram. So somebody says, hey, I'm married to a U.S. citizen. We went to the first interview. I got my temporary green card, but we're currently going through a divorce. How do I file to adjust status for permanent residence? Well, I am so sorry, Dice, that you're dealing with that. Nobody ever wants to deal with that. So you don't need to file for adjustment of status because you're already a green card holder. So what you basically have is a temporary green card. And for those that don't know what that means, a temporary green card is basically a 2-year green card that you're given. And you're usually given that if at the time they approve you, you've been married for under 2 years. If you've been married for over 2 years, you usually get a 10-year green card. So when they give you that 2-year green card, within 90 days to the expiration, you want to file for what we call a removal of conditions in your green card. So if you and your spouse are together, then that's an easy task. You file for removal of conditions together. You both sign the petition. Provide proof that in the last 2 years, you guys have accumulated to show you still had a bona fide marriage. In your case, you're divorced. So even though you're divorced, you are still eligible for an exemption based on divorce. However, you must still show that you had a good faith marriage. So you can't just say, okay, here you go. This is our divorce decree. We're divorced, but we were married. So, or be like, well, here's our marriage certificate. We had a good faith marriage. That always cracks me up. And I know it's due to innocence or not knowing. When clients say to me, well, we have our marriage certificate. Isn't that enough bona fides? Your marriage certificate is not enough bona fides. When you have a conditional green card, they are looking for evidence after you got your conditional green card. So they don't want you to submit stuff from the year that you got married or the time that before you got your conditional green card. So like if you're submitting taxes and you got your conditional green card in 2021, they're not interested in taxes from 2020 or 2019. They want to see 2021, 2022, and 2023 when you're filing your stuff. So the timeline of evidence that you want to look at is a timeline around after you got your green card. So yes, you can submit, and ask for a waiver based on your divorce and, obviously have your testimony or statement of why your marriage didn't work, but it is still critical to explain your good faith marriage and provide bona fides or provide a really good reason why you don't have them. Okay. Okay. Let's see what else we have here. What if you're married to a green card holder and you don't overstay your time? Is it best to go back to your country and start the paperwork? Shauna, so I can't answer that question because that is a family decision, that is a family decision between spouses to decide what's best for your family. But if you did not overstay your time and you've been here more than 90 days and you have a 6-month visa and you're married, you can definitely try to adjust your status while you're here, or you could consular process. It will really be up to you and your family and what works best for you. Okay. Elvis says, good morning. I filed a VAWA after a year. I filed VAWA after a year. I've yet to hear anything from USCIS. Okay. When you say you're yet to hear anything, have you received your filing receipt? Have you received biometrics? Have you received prima facie determination letter? Or are you saying that you've just not received an approval? If you've not received anything at all, I would be concerned to make sure that your case is actually pending and that it was actually filed properly to the right place. But if you've received a receipt, or you've received biometrics, or you've received your prima facie determination letter, then it just means that you just have to wait and ride the wave. Most VAWA petitions takes 2 years to 2.5 years from start to finish of the entire process. So it's just a matter of being patient. Hopefully if you filed it with an adjustment of status, and you filed it correctly, you should be able to get your work permit. So Elvis, it really depends on what exactly you filed, but you can call me and then we can go over what you filed to see what's going on. My number here is 407-995-6567. For those of you on Instagram, my number is on my profile. For those of you on YouTube and Facebook, it is scrolling through the ticker on the video. Okay, let's see. Peter says, if you're no longer living with your U.S. citizen that filed for your kids, what will happen? The answer is that it really depends, So she filed for your kids. Does she still have a relationship with your kids? So it just really depends, because you and her divorced doesn't mean that, she doesn't have a relationship with your kids, if she felt those were her stepkids, because you said you're no longer living. You didn't say that you're divorced, right? So it just really depends. Olubukala says, good morning. Good morning. Incredible Queen says, good morning. If you're a green card holder who just recently got married outside of the United States, where your current U.S. address is not displayed on your marriage certificate, will USCIS still accept it? So, your marriage certificate, the way USCIS judges marriage certificate is based on whatever the requirement is of the country where you got married. So USCIS uses a reciprocity schedule. So if you got married outside of the United States, if your marriage certificate looks like what it's supposed to look like in your home country, that will be an acceptable marriage certificate. It's not about what address you live in or don't live in, because if you don't live, so because I don't know if you live in America or if you don't live in America, did you have like a destination wedding? Is that what you mean? So the answer really depends. So then says, hi from Ohio. Hello, I'm from YouTube. Someone says, is there a difference between unlawful presence and being out of status? Yes, there is a difference. So let me just explain that difference to you. So being out of status means that, let's say your I-94 stamp says you should only be in the United States till August 31st, 2021. So today. So as of tomorrow, you're out of status, okay? And then you begin to accrue what we call unlawful presence. An unlawful presence basically means that if you accrue up to 6 months of unlawful presence, you will face a 3-year bar, a 3-year ban from entering the United States once you leave the country. If you accrue up to 1 year of unlawful presence, you will face a 10-year bar or ban, whichever word you want to use, from entering into the United States. So you start accruing it. If you don't accrue up to 6 months, you are not subject to the ban, but they could give you a hard time. So you just have to have a really good reason of why you overstayed your time. Okay, so this is Bavin on YouTube. Hello, my cousin's abused by her hubby, but she does not have any proof that they live together, and she only has marital proof photos. They have kids. They have kids. She has kids' birthdays pictures and some picture of her husband. I'm pretty sure we can find some proof. Call my office. Tell them to call my office, and we will go over it with her. Fauziat says, good morning. Good morning. Femi on YouTube. Oh, we have a lot of YouTubers here today. Good morning, guys. Got married to a U.S. citizen and had a child. I filed for Form I-360 for VAWA and also the form for work permit in June 2021. Got my prima facie. Would I get my work permit? Well, Femi, your question is a bit vague. Did you file an adjustment of status or just a work permit? If you file just a work permit, no, you're not going to get a work permit until they approve your VAWA case, which could be about a year from when you submitted it. So if you submitted it in June of this year. It could take, did I say about a year? About 2 years. It could take about 2 years for you to get your approval. However, if you submitted the work permit form with an adjustment of status and selected the right category, then you should be able to get your work permit. Fuziad is from Benin Republic. Wow, that is so cool. You guys are like our neighboring country in Nigeria. Dimitri says, good morning, tuning in. I got my driver's license with prima facie. Yay, whoop, whoop, whoop. That's awesome. Peter says, if I'm no longer, did I answer this question already? Says, if I'm no longer living with my U.S. citizen that filed for my kids, awaiting approval for my kids' approval, what will happen? I'm a 10-year green card. Peter, what are you worried about? You're a 10-year green card holder. If your kids don't get approved, you can file for your children. Okay? Get it for your kids. Don't worry about her. Good morning, Miss Chidoway. I have some questions about when to get a psychological therapist report. Is it after filing for the VAWA petition or before or during the marriage? So there's no rule to that. There's no rule to that. When you're submitting a VAWA petition, you're just showing a pattern of abuse and how that has affected you emotionally. If it was me, I even think that it's better to actually, as you're going through it, if you get therapy, that is more credible, in my opinion. If I was an officer, I don't know what officers do. I'm just telling you, if I was an officer, that is more credible to me if somebody is seeing a therapist, even before they submit an immigration application, because it's showing that this thing has been affecting you mentally for a long time. Another option is you can submit it. A lot of times we as attorneys, depending on what's going on with your case, will say, well, go get a psychological evaluation. Let's know what's going on with you mentally. Like if a client says to me, man, this stuff is affecting me so much, psychologically and emotionally, I'm losing weight, my blood pressure is high, I can't eat, I'm having heart palpitations. I will send them to go get therapy, because it adds credence and, validity to your case. And then even if you've submitted your VAWA petition, and at that point, that's when you have the courage, because for some people, that's when they have the courage, because they feel like, they're doing something for themselves, or maybe they've gotten their work permit. Now they want to go see a therapist. You can still do it then. So there's no give or take time or anything like that. But obviously, the earlier you can do it, the better. But all therapy notes and all evaluations are valid. Okay. Sorry, Instagram. Somebody says, can I apply for a work visa after my J1 visa while I'm still in the U.S.? Well, honestly, the answer depends on what kind of J1 you are here on. Some J1 waivers require a 2-year residency requirements in your home country, where you have to go back to your home country for 2 years. So all that is dependent, Okay, someone says we're getting a divorce because he wants to go be with his ex-girlfriend. Then screw him, file for a divorce, let him divorce you. Just make sure you provide all the proof to show that, you have your bona fide, and, just go get your green card yourself and find somebody better that deserves you. So Shauna says, thanks, I'm going to give you a call for a one-on-one. Awesome. All right, let's see what else we have here. Oh my goodness, I'm so out of time. All right, one more question and I gotta go. Good morning. My mom overstayed 1 year out of the country on her green card. Heard that President Biden is extending green card holders. No, it is not true. She's going to probably be stopped at the airport. She's going to have to face either an abandonment of her green card, and she's probably going to have to apply for it again, but it will just depend on what happens when she comes through customs. All right. Okay, guys, I really do have to jump off today, but I will try to be on here tomorrow. I will be live tomorrow at 11 a.m. Eastern Standard Time, 11-ish a.m. Eastern Standard Time. So if I didn't get to your question, definitely love for you to join us tomorrow and ask your question, and hopefully you'll be one of the first that I will try to get to. All right, guys, I hope you have a wonderful rest of your day. Bye.